Did you get a notification on your computer as it's
Yeah,
loading? Okay,
just
good.
press got
Yes,
it.
it did say that. All right. Let's get started. I've seen we have almost all our participants in. Okay, let's start with a quick introduction of me. My name is Alia Sheikh, and I am an associate cloud application developer with AWS. I am here today to moderate this session, and I am very excited. But like Aditi mentioned, the man of the hour is Mr. Phil Kuck. So let's introduce Mr. Phil. So Mr. Kuck is basically globally recognized immigration lawyer, assisting clients worldwide with their immigration needs, including visas, labor certificates, citizenship matters. He has a successful track record in federal court and the U.S. Court of Appeals, focusing on immigration issues. Phil represents diverse clients, including multinational corporations, technology firms, investors, entrepreneurs, families, as well as asylum seekers. He graduated with honors from Georgia Tech University College of Law, where he excelled in various legal activities. So basically, he is an expert, and we're all very excited and very happy for him to be here and share his expertise with us. Thank you, Phil. Thank you for being here. We're so excited. And without any further ado, I'm just going to give it away to you. Please take away.
Sweet. All right, so I'm gonna put this on. I'm gonna share my screen here, so you guys don't have to look at my face most of the time. All right, let's go. This. All right. Out here. All right. All right. So welcome to my presentation. Today's topic we're talking about is just going to be for students going from an F1 all the way to a green card. And we're going to cover the F1 all the way. So there's going to be F1, what you can do on your F1, what you can do for work, and then that subsequent non-immigrant visas in between them, because most of the time you're not going to go straight from an F1 to a green card, and then obviously the green card at the end and the different pathways that can do that. And we're also going to answer a lot of the questions that you guys submitted when you registered. I've only created a couple of slides of the ones that I thought that really stood out, but we'll go through a lot of the others. I will say that I'm not going to go over all the questions. A lot of the questions that I received, I believe, happen to be more individualized and personalized, and I think that you might want to seek advice from an immigration attorney, whether that be me or someone else. But my contact information is all here if you want to reach out to me afterwards to just get my impression of your individual personal case. Then I'm happy to do that. So let's move on. So kind of discussed this already. We're going to start with employment options as an F1 student, go to non-immigrant visas and immigrant visas, then common issues, immigrant visas. So immigrant visas, I mean, green cards, right? So you're an intending immigrant, meaning you're a green card holder. And then finally, questions. So employment options as an F1 student. So first of all, we start with bad news. The bad news is that there's no protection from employment discrimination in the United States for F1 students. An employer's policy not to hire positions in F1 OPT CPT status is permissible. And I put this here just because I've gotten a lot of questions on it. The students have come to me and said, hey, this employer that I applied for, turns out that they won't hire an F1 student, and are they allowed to do that? The answer is always yes. So what are your employment options as an F1 student? You can do pre-completion OPT. You can do post-completion OPT. Remember that you have only 12 months absent a STEM extension. Okay. You can do CPT, off-campus and integral part of course curriculum. and what qualifies as volunteer work. If you're going to do something like this, is you want to check and see whether the activity, whether it's less than full time, whether the services you're offering are free, whether the services you're typically associated with are volunteer work, and whether any regular employees would be displaced, and whether the worker, you, the volunteer, would receive or expect any benefit. So for OPT, we're just going to go through a lot of the basics here. We're not going to go in deep dive because I could probably teach a course on it, every single slide in here. So for OPT, you must apply for OPT 90 days prior to your graduation. OPT is valid for employment after the employment card is issued. Your first 12 months can be unpaid. Extensions of the OPT are available if you're a STEM grad. You get 24 months total there. So for the STEM, OPT is valid for work within your field of study. For a STEM OPT, you have to have a training plan, which interferes with the ability to, I guess, open your own business on an F1 if you're trying to do it through a STEM extension. So, but we'll talk about that a little bit later. It was one of the questions I had. You want to beware the H1B gap, and we'll get to H1Bs in the next slide. So just make sure that you have applied on or after April 1st for the H1B, and then the gap will extend as long as you're still on the F1 status after you've applied for the H1B. So we typically recommend that you have proof of the FedEx first filing. If there's any issues, you can show that you send it in, and then obviously the receipt notice if it's accepted by USCIS. So we go on to non-immigrant visa options. After you graduated, and presumably while you're on OPT, a lot of people apply for the H1B status. And first of all, I would like to apologize to everyone in the nation for the recent H1B crap that's been going on, for lack of better words. It's over 700,000 applications for 85,000 positions. I think it comes out to like a 12% selection rate. But essentially, no one was ready for those kinds of numbers. We don't really have a super clear picture of exactly what's going on, but we have, we have a little bit of an idea. And it looks like there might be some issues there that need to get cleared up. So with the H1B, it's for people with specialty occupations, right? And special occupation requires at least a bachelor's degree in the specific specialty. As an industry minimum for entry-level position. And that's why you get a lot of nurses that can't get on the H1B usually, because for nurses, they typically don't require a bachelor's degree. You need the prospective employer for the H1B must have had that specific degree or its equivalent. So its equivalent meaning that if you got it in a foreign country, you can get that evaluated to make sure that it's equivalent to a U.S. bachelor's degree. There's no requirement for unavailability of labor for the H1B. So the employer needs to make sure that they're able to pay the prevailing wage for the occupation in the geographic area of intended employment. And generally, all H1Bs start on October 1st. Caps on H1B visas. So I'm sure most everybody knows this, but just in case that people don't, I just want to make sure we're going over it. So 65,000, really it's 58,000 visas, and that's because there's special visas, special H1B category visas set aside for nationals from Singapore and Chile. And there's additional 20,000, which makes that 85,000 for people with master's degrees. So those are all gone right now. They've all been selected. The H1B is selected by lottery, which we just talked about. It's a newish program right now, a program that obviously has its flaws. It includes a pre-registration first with a $10 fee, but it looks like that's going to be increased to a $215 fee, likely to in an attempt to decrease the risk of fraud here. If you're selected, then you file the H1B within 90 days of your selection. And processing times are estimated to still be about the same. For the government filing fees and the attorney fees, a lot of people have asked this question when they submitted questions. So you cannot pay the fees for an H-1B. They must be paid by the employer. And they're not even allowed to pass on the costs to you later on. It's super illegal. So be careful if any employers are asking you to do that. They could get audited and they can get in a lot of trouble. It just lays out the filing fees. It's $1,700 to $2,400 plus $4,000 if the company has greater than 50 employees that are on an H-1B, L-1B, or an L-1A. All those together, there can't be more than 50% there. Your maximum stay on an H-1B is 6 years, with possible extensions if you get a perm labor certification, or sorry, if the perm labor certification has been pending for 365 days or more, if the I-140 has been pending for 365 days or more, or if you have an approved I-140 and you're not able to adjust status yet. Right, so the standard processing time for an H-1B visa petition is typically 3 to 6 months. However, there is premium processing. You can get it real quick for you, 15 days. Persons on a valid H-1B visa already, they can port to a new employer upon filing of the new H-1B, though you do need to make sure that the new employer has filed prior to your authorization of stay expiring, right? And so that's been a big issue recently, obviously, with all the tech layoffs. You've had 60 days to find a new job, and that's been very stressful. Though I remember reading in March that that it had been recommended that USCIS adopt a new rule to extend that from 60 to 180 days, which would obviously be a very welcome addition to that process. Okay, so done with H-1Bs for now. TN professional work permit. So I don't know how many people from Canada or Mexico we have on this call, possibly none. But the TN professional work permit is a really good alternative and method for people from those countries. And also, you know, once we get to the end of this program, if it turns out that you do not like your prospects of immigrating in the United States, there's always Canada. Canada has a great immigration system. There's a bit of a backlog there as well, but they have plans to accept, you know, I think another 1 million immigrants into Canada this next year. You know, you go and you get their equivalent of a green card within about 3 years, and get citizenship after another year in Canada, and then you can come in on the TN visa back to the United States. So it could be a fun little workaround, though obviously that would take some time. So the TN visa, it's available to all citizens of Canada and Mexico. You get temporary entry, and that temporary entry is for 3 years to engage in activities at a professional level. So you can get as many extensions as you want, as long as there's not really an intent issue. The TN visa, unlike the H-1B visa, is not a dual intent visa, meaning that when you get the visa, you can't intend to immigrate permanently to the United States at that time. That doesn't mean that you can't apply for a green card while you're on the TN visa. It just means that, you know, you can't have intended to be an intending immigrant at the time of getting the visa. So the next one we're going to talk about are L1 intercompany transferees. I've done a lot of these. USCIS approves the L1 visa status. For Canadian L1 applications, another advantage to going to Canada, right? Canadian L1 applications, they can make their applications at the ports of entry, meaning you just show them a pile of paperwork and they wave you on it. You know, it can take only a couple hours and you can be in the United States on an L1. I know it's not fair. They also have these pre-clearance stations at the airports where you can do that as well. Your initial entry is 3 years, except if you're setting up a new office and it's only 1 year. You can get extensions up to a maximum of 5-year stay for employees with specialized knowledge, and 7-year stay for managers and executives. The eligibility requirements for an L1. So there has to be a U.S. company and branch, and that must be either a parent, subsidiary, or related affiliate company to that U.S. company or branch. The prospective transferee must have been employed by the foreign related company for at least 1 consecutive year, and the consecutive is important, out of the previous 3 years immediately preceding your last entry into the United States. So if you want to qualify for this, you're in the United States now, you would have to leave the United States and work for a U.S. company that has a branch elsewhere in the world for at least that 1 year. The prospective transferee must have also worked abroad in the executive managerial capacity or in specialized knowledge, right? And specialized knowledge is really amorphous. You can make it anything you really want to. The O1 visa, I had a few questions about the O1 visa, so important to cover this as well, because the similarities to the EB1A are there, right? We'll talk a little bit about that. So O1 visas are for persons having extraordinary ability in sciences, arts, education, business, athletics, or the entertainment industry. You must meet at least 3 of 8 factors, and those factors are receipt of a big award, and we're talking about big, not just, an award, right? So maybe not Nobel Prize. I mean, that would certainly satisfy it, but it's got to be something in a nationally or internationally recognized award. You want to be membership in an association. That's not just any association. You want the association to require big things of its members, right? Think of the top. Maybe there's an association for the top 5 or the top 500 immigration attorneys in the country. That would be, I'm in the top 500, so I'm in that thing. That would be that kind of membership and association. Published material about your work, that is helpful. Original contributions, like patents or new discoveries. I had one that I discovered a new way of mapping certain genomes, to solve cancer and all that stuff. That helps. Scholarly articles. If you have a high salary compared to other people, that's very helpful. You want to be on a panel or as a judge and judging the work of others. We have a separate slide about that because I had a question about that. Employment with organizations with distinguished reputation, and you need to have a leading or critical role in those organizations. I also have a slide about that because that's one that I got a lot of questions about, and it's also very hard to satisfy. So you can file for an O1 if you're subject to a J. If that the J visas have a 2-year foreign residence requirement. We'll briefly go over the J in just a second here. But you have to consular process for that for the visa. You can't just change status here in the United States. So for the J1 visa, those are for visitors and scholars that are here temporarily. They have a 2-year home country foreign residence requirement. It can be a variety of fields, trainees or interns. We help a lot of schools out here in Utah actually with teachers who are doing dual language programs. And a lot of them are on J's as interns. There's waiver options, right? So you can get a no objection waiver from the Department of State. Those are actually pretty easy to get. You just have to get a letter from your consulate saying that, and then the Department of State approves it, and you can go about your business with the other change of statuses you need to. There's no gap coverage, so you need to make sure that you're not overstaying. There was a new unlawful presence rule for FJM visas, but there's an injunction on it, so you guys don't really need to worry about it for now. I guess if you hear that injunction's been stayed, then think about that. So the E2 visas, those are for treaty traders and investors. So what I mean by a treaty trader or a treaty investor is that your home country and the country you're in now, the US, they have to have had a treaty, right? And you can easily look that up. There's a link here at the bottom of the slide here to see whether or not your country is a treaty country. So you have to have a treaty with the US and birth citizenship and your citizenship country. There's a marginality requirement to ET visas, a requirement for investment at risk. There's no set amount. We generally try to say, $200,000 or more. Sometimes less, depending on the consulate and the nature of the business. I've heard e-visas getting in on like $1,000 or less. You always hear those crazy stories. Personally, I always recommend it to be higher than that, but you're there. You can also get, as an essential employee, you don't have to be the leader of the business, right? You can get an E2 as an essential employee. So that's something to explore there. All right, onto the juicy subject, and that's immigrant visas, your green card options. So there are 675,000 total visas that are currently allocated to both family and employment-based categories annually. And guess what? Most of those are going to the family-based categories. Only 140,000 of these are for your employment-based immigrant categories. And that is what is making the huge backlogs, right? Well, at least part of it. The other part is what we're talking about next. And that's that each country is allocated a maximum of 26,000 permanent visas annually, 6.7%, right? So this is the country caps. Immigrant visas are allocated quantitatively under preference categories. So when you hear me say EB1, that means employment-based visa first preference, and so on, second preference, third preference, fourth preference, right? So there are currently massive backlogs for certain countries, India and China, you know what I'm talking about. And it's something that a lot of immigration attorneys aren't talking about right now is that I think there are soon to be long backlogs for everyone, right? And that has to do with us being in the golden age of national interest waivers, EB2 visas. Also has to do with the USCIS making changes, and they've put certain categories into force certain categories like religious visas into the EB3 essentially, and changed the SIJS status and all that. And so there's a lot of changes right now that I think are negatively affecting backlogs for everyone. All right, so let's talk about the first one, the EB1, first preference category. So we'll talk about the first one that everyone's probably most interested in, and that's the extraordinary ability visa. We call it the EB1A. You're looking for at least 3 out of the 10 criteria. It's pretty much the same criteria that we already talked about under the O1. You're looking for a one-time achievement, like a major international award, or at least 3 out of those 10 criteria. You can self-petition for this, or you can get your employer to sponsor you, which I've also had. I didn't expect to have, but I've had an employer sponsor for an EB1A, and it went well. But you don't need that, and you can self-petition. If you already have an O1 under sciences, athletics, business, education, you might already qualify for an EB1A. And so a lot of times you'll hear an immigration attorney recommend that you try for the O1 first before you do the EB1A, because getting the O1, though it doesn't necessarily mean you're absolutely going to get granted an EB1A green card, it is a good indication that you will be able to get the EB1A, because they've written this language into the EB1A category that gives USCIS a little bit more scrutiny. It makes it a higher burden under the EB1A than the O1, even though the language of extraordinary ability is very similar. Aliens with I hate the word aliens. So, I mean, immigrants with the extraordinary ability in the arts and sciences, business, education, or athletics. There's also the EB1B, outstanding professors and researchers category. So that's just the second one. And, those do need to be employer sponsored, but they are they're good too, right? So, I mean, you just have to be able to show your research and make sure to show that you are outstanding in your research, but it's very doable. EB1C had a few of these out in Utah. We have a lot of big startups out here. Multinational, it's for multinational managers and executives. You just have to be a manager and executive, right? 40,000 of the 140,000 that we talked about earlier are allocated annually for these first preference category green cards. And right now, before, a couple months ago, there's no backlog for Indians or Chinese nationals. And now it appears that there is a new backlog for first preference categories, just because it appears that with the new administration, there's been a increase in approvals for these categories. for this first preference category, which is great that we're getting more approvals. Not great that there's a backlog, right? So the other major significant thing for first preferences categories, green cards, is that there's no labor certification required. And labor certification, not having that is really great because that is what slows down so many in the EB2, EB3 category, because the Department of Labor, essentially is just not doing their job, or they've only recently started doing their job, and those have been taking longer and longer to get approved. So let's talk, before we get to the perm stuff and all that, let's talk about the national interest waiver. National interest waiver is in the second preference category. It's not extraordinary ability, but it's exceptional ability. Persons with bachelor's degrees or 5 years experience, or master's degree. If you have a master's degree, then you can skip all that crap about the exceptional ability, which is nice, right? So there is, as of December 2016, there was new criteria for the national interest waiver. Before 2016, we didn't really even know what was going on, right? Because it was really an ambiguous kind of standard for national interest waivers. And basically the old standard was that the work is national scope and in national interest, and no one really knew what that meant. Everyone kind of had an idea, right? But then with this matter of Domisar, a new standard was implemented, and we're much more able to assess how successful an application is going to be based on these new standards, right? So we learned that with substantial merit and national importance, it's not just based on geography. There was that question before. You have to be well positioned to advance that endeavor of national importance. You might need, you don't need to show what your economic impact is going to be, whereas that standard might, that was ambiguous before as well. And you just need to be able to show that the U.S. will benefit even if there are other qualified workers available. This is great, again, because you can self-petition for it and you do not need a labor certification. Now, for the others, this is the other EB2, right? And so these are for members of professions holding advanced degrees or persons of exceptional ability. So these are labor cert required. You just need a U.S. or foreign degree equivalent above a bachelor's, right? So I'm probably assuming that a lot of people will get put in this category if they're not going for a national interest waiver or an EB1A by their employers. And these ones do require a labor certification. EB3 is the same, except it's just for people with professionals with bachelor's degrees instead of the above bachelor's degrees, right? Or skilled workers with at least 2 years training or experience. There are obviously big backlogs for everyone for the EB2s right now. For perm labor certifications, right? So you have to go through both the Department of Labor and USCIS for non-national interest labor EB2s and EB3s. The employer, as part of this perm labor certification, they have to conduct a good faith recruitment effort, and they have to show that there are no qualified U.S. workers to do the job. The recruitment efforts typically, they include 2 Sunday newspaper ads. If it's a professional occupation, they have to do 3 additional forms of recruitment that are, laid out in the regulations, and your immigration attorney will know how to do that. So what are the common issues? So priority dates and the line. So a lot of people don't really understand what a priority date is. That might not be true of this group here, but just to be safe, the priority date is the date of filing your perm application or the date of filing your I-140 immigrant visa petition. If the preference category is retrogress, which you'll see in the visa bulletin that I've linked below, right? You cannot file an I-485 adjustment of status until that priority date that we just defined is current. So you can go to the State Department. I always just Google it. I don't follow a specific link. I would just say Visa Bulletin, Department of State in Google, and pops up the most recent one. I believe this is for the April one, but the May one is out now. And so you go down, you'll go, I've had questions about how to read the Visa Bulletin before, so I'm gonna do my best to do it here. So you'll go down the list, right? You'll skip past the family-based ones unless you have a family-based green card. pending there, and you'll go to the employment based, and there's two charts. There's the final action date, which is the first one that will pop up, and the dates for filing one, which is the second one that will pop up. And if you're in the United States, you're going to be looking at the dates or the final action dates chart, because even though this is something that is given by the Department of State, USCIS adopts it, but they choose whether to adopt the final action dates chart times or the dates for filing times. And right now, USCIS has chosen to adopt the final action dates times, which means that you can only file your AOS petition when your visa is current according to the final action date chart, right? And that stinks because, you know, the dates for filing chart is a lot sooner, especially in that EB2 category. So it's actually interesting because if you are applying from abroad, consular processing, you can actually file for your green card a lot sooner because you can use the dates for filing chart through the Department of State. And that's interesting because you know, they'll have your application, and presumably, you know, I'm not in the minds of the Department of State adjudicators, but presumably they'll have taken a look at it and have it ready to adjudicate by the time your date becomes current for the final action date so that they can approve it, right? It stinks because in the United States, you can't do that. You can only file once it's current for the final action date, and then you have to wait however long for USCIS to do that adjustment of status, to adjudicate that adjustment of status application. Some common green card issues, some others. So I get the question, when do I start my green card process? If you're on an H-1B, 3.5 years into your H-1B, and that's just because, you know, I used to say 4.5, I say 3.5 now because the perm labor certifications, if you're doing that process, it is going to take, it's just taking longer and longer. So, you know, I hopefully get shorter than that and I can change it back to 4.5 years, but definitely start looking at it 3.5 years in at the latest, right? Or obviously much sooner if you're Chinese or Indian, given those backlog issues. So you want to make sure that you like your employer and vice versa, because you're in it for the long haul, right? Absent porting, which you can do, you can port. If you're STEM OPT eligible, you might be able to get a green card within 3 years. But I'd still recommend that you try for the H-1B because, you know, because times are getting harder and they're getting longer and longer for adjudication for everything for the Department of Labor and USCIS. So still definitely try for the H-1B or any of the other non-immigrant visas that we've talked about. Or, you know, you could just simply try for the green card, like we said earlier. So you want to be prepared for denial and the possibility of your employer litigating in federal court. It definitely happens. We've done this before. If it gets denied. So travel. Another question we get is, will I be stuck here once my green card application is filed? So probably not, right? You run into the issue of people being stuck here more often when it's family based, right? Because a lot of times they'll be undocumented and they will not have travel permits until that travel permit comes through for their adjustment of status application. So you need a valid non-immigrant visa that allows you to travel, or an advanced parole travel document. It's a myth that you can't travel once you file your green card application. So L or H visa holders can travel on a H or L visa. You don't even need advanced parole. Other non-immigrants like E's, O's, P's, R's, you have to wait for your advanced parole. And that takes about 6 to 8 months. But after you get that, then you can travel. What happens to the green card if you change employers? So you can keep your green card. You can port, right, to a new employer if you have an approved I-140 and these other 4, right? So you have to I-485 pending for more than 180 days. Your job is same, your new job is same or similar position as the old job. You will need a letter from the new employer for portability purposes, and you'll need to file a supplement J for the new job. All right, so I'm just going to answer a few of the questions that I got here, and then we can go over them. some of the others that I didn't get to create slides for, again, like I said before, if they're too personalized, I'm probably not going to talk about them. Then we can, I guess, open up the floor after that. So how long does the process of obtaining a green card actually take? That is a great question. And I think we covered it pretty well, but the answer is it depends, right? So for an EB1, EB2 national interest waiver, you have premium processing available to you. For an EB1, you have 15 days premium processing. For the EB2, it's very new, but you have 45 days. So what we've been seeing on the EB2's premium processing that I've done is actually been seeing 20 days or less usually. That could get longer as time goes on, as they get more national interest waiver applications, but that's what we've been seeing. If you don't do the premium processing, I'd still probably put an I-140 adjudication within about a year. That's probably what I'd say. The times on USCIS might say longer than that, but I also think that they overinflate those times on the USCIS processing website. So for the EB2 or the EB, I meant to put EB3 there with perm, probably 2 to 3 years, right? So that's how long it's going to take with that. How do you define a critical role under the EB1A if you're not a manager? Well, that's a really good question, and it's very, very complicated, and it's typically a standard that I don't like to include because it's so difficult to get it approved. But you know, that doesn't mean that you shouldn't try if you really have a leading or critical role in a distinguished organization. So the regulation here, 8 CFR 204.5, H3, whatever that Roman numeral is, the quote, evidence that the alien has performed in a leading or critical role for organizations or establishments that have a distinguished reputation. I put the stress on the S, as you'll see going forward. So it's pretty complex, very inflexible. A lot of people are like, oh, well, I'm a manager. So, you know, I mean, even if you're a manager, it doesn't necessarily mean that you have that leading or critical role, right? So the first thing I want to stress is that you need a leading or critical role, right? So language in the regulation, it doesn't say and, right? So not both. Your evidence must establish that the individual has been a leader or has somehow contributed in a way that is of significant importance to the outcome of the organization's or establishment's activities. It is not the title of the role that matters, but rather the individual's performance in the role that determines whether the role is leading or critical. It's easier to satisfy if the role is leading or critical to the org as a whole rather than in specific circumstances. So it's not necessarily that it can't be done, right? So if you're a leader, if you're a director or executive, if you have a director or executive level position for a large organization, say you're vice president of Amazon, you're probably going to satisfy this requirement, right? Vice president, director of engineering, those are some examples that I put. You'll probably satisfy that. Senior manager probably won't qualify as just leading, and that's because there are other leaders or directors above them that are performing the duties at a higher level, right? You're reporting to other people. But that doesn't mean that you can't qualify here, because you could say that it's critical if you can provide evidence that your contributions to the organization has substantial impact via cultural, educational, economical, or reputational advantages. If you're not a manager at all, but you can still show that, you know, your role is critical, it's possible that you could satisfy this, though I don't think that it's very probable. Right. The other thing that I want to say here is that organizations must have a distinguished reputation. And that is in a plurality. If you recognize the S's on the organizations and establishments, the org must be recognized as having you want to make sure that there are more, you know, you perform leading roles in multiple organizations, right? So your org must be recognized as having a distinguished reputation. Think US News, World Reports, awards, major media coverage, etc. It's kind of like your employer also proving that they're EB1A, if you think about it, right? So next question, what do I have to show as evidence of my participation in judging the work of others? So you want to show the evidence that you have been specifically invited and have participated in judging the works of others in the same or an allied field. I got the question of whether I can volunteer to judge. Really, volunteering is probably not going to satisfy it, right? So you want to have been you want to have someone reach out to you, you want an email saying, hey, will you come, judge this thing on other immigration lawyers because you're an immigration lawyer and you're a good one, right? That's the kind of thing you're looking for. Judging unrelated fields, that's not going to do. Specific examples of evidence, right? So evidence of selection criteria of judges to the event or competition. So that's kind of like the email I'm talking about, showing you've been invited. Details about the participants. Are they professionals? Are you judging other professionals? Or are you judging just, rookies or, people that have never done the thing before? It's kind of like, I use the example of mock trial, right? So if I'm doing judging a mock trial at law school, it's going to be more impressive to USAS than if I'm judging a mock trial of high school students, right? Just because there's more experience there, presumably. Maybe give them the names of other judges or the significance of the event or the significance of the journal, right? So a lot of people will do peer reviewing. A lot of people will do peer reviewing if they're in the sciences, right? So they'll have written maybe other articles, and those journals have reached out to them and say, hey, will you peer review some other articles for us? Being able to show that journal has market value will be very good. I think this is my last slide, but the question is, can I start a business on an F1 visa? Yeah. On OPT, you can, right? So an F1 visa holder must maintain full-time student status and not engage in gainful employment without employment authorization. An F1 visa holder may enroll in CPT OPT. An acceptable employment during the standard pre and post completion OPT include multiple employers, short-term, multiple employers, work for hire, self-employed business owner. But this is the key, is that you can start a business and be self-employed, but for STEM OPT, because they require a training program, it probably won't fly for the STEM extensions. So, maybe up to a year, right? Because you're probably not going to get the STEM extension there. Employment through an agency or consulting firm, unpaid or volunteer work is all right, as long as it's directly related to your course of study. So if you're a scientist, you probably can't go volunteer for Barack Obama's re-election campaign. You can do part-time, at least 20 hours per week, or full-time paid employment. Acceptable employment during your STEM OPT would be employment with an employer enrolled in E-Verify who has completed a Form I-983 training plan. That's what we talked about. And you can also work for multiple employers. But all the employment must be related to your degree and enrolled in E-Verify. You can become a passive investor in existing and new business enterprises. That is allowable, right? All right, thank you. If I can be of any help to anyone here, I'm happy to answer any emails or field any phone calls afterwards, but I think I'll just open it up to questions.
Thank you so much, Phil. That was great. We're gonna pass it over to Aditi real quick for a little bit, because she wants to announce our next session before we could move over to our Q&A. So Aditi, take it over.
Yeah, thank you so much, Phil. This was, such a power-packed information session. Like this PowerPoint is worth $1,000 or more, and I so appreciate the conscientiousness that you put into make this PowerPoint so thorough. So if we can take a moment to just say thank you to Phil in the chat. I know people might start dropping off as people are asking questions, so please give it up for Phil in the chat, in the chat, sort of put some reactions. I truly appreciate it, and for you to make this more thorough. I wanted to do a shout out really quickly before people start dropping off. I have events scheduled for till September for you guys. So if you want to follow along, if you have any further questions that Phil has just scratched the surface and put that seed in your brain and you want more details, Phil is there, and we have other events coming up. We have 2 paralegals coming up. We have somebody who has gotten their EB1B who's going to share their story, somebody from EB1A who's going to share their story, somebody who's gotten an O1 is going to share their story. So if you want to follow along, please go to link.tree/this link. Oh, I just sent it to Alia only. Let me send it to everybody. If you go to this link, you will find my LinkedIn, and you will find the link to an exclusive Slack community that we run. Is exclusively for EB1, because it's for people who want to figure out what is O1, what is EB1, what is EB2 NIW. So feel free to join. I always announce the events there before I announce it to the larger audience on LinkedIn. And if you want to connect with me on LinkedIn, I'm going to drop it over here. I am hoping this is the right address. If it's not, please let me know. I will send you the right link. But thank you again. That's all I had from my side. I'm going to pass it over to Alia.
Thanks, Aditi. All right. So we're gonna open the floor for Q&A. I would love to request everyone to please continue having their mics muted and raise your hands, and then we can take it one by one. And I'd also like to request everyone to please limit your questions to one per person and to not have multi-parted questions so that we can give everyone a chance. And also in the interest of time. All right. I'm going to call out names, and then you can unmute yourself and ask your questions. Let's go with Brianna first.
Thank you, everyone. Thank you, Phil, for this session. I truly appreciate it. I have a quick question as to the green card process in terms of having a STEM OPT. So if you have a STEM OPT and you exhaust all the 3 years, how do you get your employer to do the green card process, or can you self-petition for it? Thank you.
Yeah, so we discussed that you're able to self-petition, right? You can, if you qualify, right, you can self-petition for the